Case Study 1: Biometrics. Does management have the right to demand the collection of my biometric data for attendance? Example: an employee uses a magnetic card for attendance. Management now decides to change the magnetic card system with a biometric control, iris scanner and fingerprints. The Data Protection Office advised that the proposed biometric data collection is not proportionate to the actual aim, and it is therefore necessary to obtain the consent of each employee. For cases where a consent form has been signed by employees, management may use the fingerprint system. However, in other cases where the consent of employees has not been obtained, alternative means of taking attendance must be provided, such as barcode employee card or other means such as signing in a register book. Case Study 2: Monitoring at Work. Does an employer have the right to monitor its employees at work? Under the Data Protection Act, employers are entitled to monitor employee activity only if they have a lawful basis for doing so, and the purpose of the monitoring is clearly communicated to employees in advance. This can happen, for example, when an organization videos workers to detect prevent crime, example theft, check telephone logs to detect excessive private use, monitor emails or check internet use. Monitoring is usually intrusive. Hence, an employer should use information obtained from monitoring only for the purpose for which it carried out the monitoring. Case Study 3: Internet Publications. An organization has published personal data of its customers on his website. The customer has requested the organization for the personal data to be removed. The Data Protection Office informed that information can be published for lawful purposes only, and it should be adequate, relevant, and limited to what is necessary in relation to the purposes for which it is processed. The organization was requested to remove customer personal data published as the latter had no lawful ground for publishing that information. Case Study 4: Professional Emails. Can my employer have access to my emails? Example: an employee is absent for a prolonged period. All the information relating to a particular client is found in his mailbox. In most cases, limited private use is allowed for professional emails, which thus generates a certain expectation of privacy by employees. However, employers should normally not read their employees' emails, as they may contain private information as well. In this case, for business continuity purposes, the email of the employees could be read. To avoid such problems, organizations should require employees to ensure that relevant correspondence is stored in places that are accessible to those persons who need it, such as case management systems, case files, or provided in handover notes. Organizations should have defined procedures which the staff is aware of where access to an employee mailbox is necessary, for example, in case of absence or confidentiality breaches. Case Study 5: Transparency. Can a school share the personal contact details of parents to send promotional school items? Example: a school records the personal data of children as well as the contact details of the guardian. The school shared the parents' contact details to an organization which sells school items. At the time of collection, the purpose for processing personal data of the guardians was specified as administration purposes. It was not specified that the personal data of the guardians will be shared with other recipients for the purpose of marketing. Thus, the personal data of the parents cannot be shared. Transparency is always important and is linked to fairness. The school should have been clear, open, and honest with the parents or guardians from the start about how they are going to process their personal data. Consent of those guardians who wish to be contacted for marketing purposes should be sought by the school. Case Study 6. Medical Records. Can patient information be disclosed to third parties? Doctors must make sure any personal information that they hold about patients is effectively protected at all times against improper access, disclosure, or loss. They must not leave patients' records or other notes they make about patients either on paper or on screen unattended. If doctors pass patients' data to another health professional for guidance and advice on clinical issues, the patient's data must be anonymized. If they wish to pass on the full patient's data, including identifying details about the patient, they must obtain the consent of the patient in advance. However, in cases where patient details are urgently needed to prevent injury or other damage to the health of the person, then, for the purpose of medical diagnosis or in order to protect the vital interests of the patient, the doctor may disclose the details without obtaining consent. If you have any queries regarding data protection, contact the Data Protection Office for advice.